of Terrisa Dhoray against Attorney General of Trinidad and Tobago. And
I'm afraid we've kept you waiting a few minutes. I'm sorry about that. We've been discussing this fascinating problem. Mr. Ramlogan.
My lord, my lady, I care for the appellant in this matter. With me is Mr. Robert Strang and Ms. Catherine Bailey, and we're instructed by Mr. Vishal Ciceran. My learned friends, Mr. Douglas Mendel, Senior Counsel, and Mr. Simon Delavesti, Senior Counsel, appear for the respondent, instructed by Charles Russell. I'm happy that the opening statement says that it's an interesting case, my lord.
Yeah.
Can I start?
Also a very important case.
It is indeed, my lord. It is indeed. Can I start by saying a few words about what would have led to the peculiar constitutional arrangements for Trinidad and Tobago? In 1962, we gained independence from Great Britain. The constitutional pact that was negotiated at independence was informed and influenced by certain political, ideological, ethnic, religious, and cultural suspicions and divides in our society.
Suspicions and?
Divides.
Ah.
The Trinidad and Tobago is unique in the Commonwealth Caribbean in that the racial composition of the society, having regard to the history and experience of slavery and indentureship, created unique and peculiar socio-political problems for us. That manifested itself in a political culture that was heavily influenced by and driven by racial considerations, and hence the formulation of our Constitution is one that would have been a byproduct of that peculiar history, narrative, and context. It is for that reason that when we attained independence in 1962, it was felt necessary to have a constitutional principle of political insulation for the public service. And in both the Independence Constitution in 1962 and the Republican Constitution in 1976, that principle was maintained and exists today.
Now, are you going to explain to us what you mean by political insulation?
Yes, I will certainly.
Yeah, thank you.
The political insulation principle is such that the government of the day, whomsoever that may be, the political arm of the executive government, will not have the power or jurisdiction to influence or interfere with the performance of the functions and the discharge of duties by public officers who are in the service of the state. Where the Constitution made exceptions to this principle of constitutional political insulation, it did so by express terms. For example, a power of prime ministerial veto was conferred expressly by the Constitution for the appointment of certain office holders, such as the DPP, the Ombudsman, and certain other high office holders. But that the Constitution made express and clear provision for. Beyond the scope of that limited, clear and specific provision, the general principle is a principle of constitutional political insulation. So that when the Constitution intended to have an exception to that overriding principle, it did so in clear and express terms. And that is how was this insulation achieved? It was achieved, firstly, by establishing independent service commissions in Chapter 9. And the commissions themselves were insulated from political influence and control. They're appointed by the President in consultation with the Prime Minister and the Leader of the Opposition. And I'll come to the grounds for removal and all of that. There are certain constitutional safeguards. So the commissions themselves are independent to start with. Secondly, the insulation is achieved by giving sole and exclusive jurisdiction for matters pertaining to appointment, promotion, discipline, and transfer of public officers to the commissions. Sole and exclusive jurisdiction.
I'm just taking a note. Appointment, promotion, discipline, and dismissal,
and transfer.
And sorry, and
transfer.
Yes.
Yes, because you can easily pressure or frustrate a public officer by transferring them.
Yeah.
And putting them to work the furthest possible from where they live. And you put them to work in a rural part of the island, for example. And that by itself. So the insulation principle covered a large area, as it were, including even the transfer of an officer. So it's appointment, discipline, a promotion, and transfer. And finally, the most important thing and the greatest clue here lies in the entrenchment of the provisions that establish service commissions. The structure in Chapter 9 is deeply entrenched in our Constitution, so that there is a constitutional reinforcement of that independence given to the commissions by a deep-seated entrenchment, which you will find in Section 54, such that an amendment to those sections are only possible by a 2/3 majority in each House of Parliament. And the natural question arises, well, why would the framers of the Constitution have felt it necessary to go to these extreme lengths to A, establish independent service commissions, B, vested with sole and exclusive jurisdiction for matters pertaining to appointment, promotion, discipline, and transfer, and to restrict Parliament's ability to amend that Chapter 9 by imposing a deep-seated entrenchment which requires a 2/3 majority in each House of Parliament. And the answer has got to be, the purpose was that the political insulation principle was deemed to be sufficiently important to a young nation upon the grant of independence, given the suspicion, the fears that existed given our unique socio-political problems. The pact negotiated, when one looks at the debates in the Constitution debates, the public consultations, and the conference at the Great Marlborough House, when you look at it, you will see the Indian community was in a minority, so that there were fears and suspicions. And the pact that was negotiated at independence to give protection included, in particular, the arrangements that we have devised for the Republic of Trinidad and Tobago. Now, it is against that backdrop, that we then come to this appeal.
Well, can I, before we go further forward, so who, you say that protection was given, who was the protection being given from? Or who or what were people being protected from?
Well, I think the answer to that, Lord Diplock has given the answer to that in Endell Thomas, and I can take you now to that.
Well, I don't want to take you out of your order.
No, that's fine, Lord. it's a logical flow. Can I take you to the electronic bundle, page 4678? 4678. And this is the famous case of Endell Thomas and the Attorney General. And this was decided in 1981. And in the West Indies, Lord Diplock is widely regarded as one of the grandfathers of West Indian constitutional jurisprudence, followed closely by Lord Bingham and, of course, many other distinguished judges from Her Majesty's board. But if I can take you to page 4678, letter G. And it says, paragraph G, under a party system of government, such as exists in Trinidad and Tobago, and was expected to exist after independence in other Commonwealth countries whose constitutions followed the Westminster model, dismissal at pleasure would make it possible to operate what in the United States at one time became known as the spoils system upon a change of government, and would even enable a government composed of leaders of the political party that happened to be in power to dismiss all members of the public service who were not members of the ruling party, and prepared to treat the proper performance of their public duties as subordinate to the furtherance of the party's political aims. I go to the next page, letter B, 4 lines down from page 4679, just the next page. Their lordships do not suggest that there is any likelihood of any of these extreme consequences of the existence of a legal right of summary dismissal without cause occurring in Trinidad and Tobago. But what has actually happened in some other countries suggests that the possibility of their occurrence was not too far-fetched to justify the constitution makers in the 1960s making provision to eliminate any such risk in constitutions which follow the Westminster model. The whole purpose of chapter 8, now chapter 9, which bears the rubric the public service, is to insulate members of the civil service, teaching service, and police service from political influence exercised directly upon them by the government of the day. The means adopted for doing this was to vest in autonomous commissions, to the exclusion of any other person or authority, power to make appointments to the relevant service, promotions and transfers within the service, and power to remove and exercise disciplinary control over members of the service. At letter F on the same page, in respect of each of these autonomous commissions, the Constitution contains provisions to secure its independence from both the executive and the legislature. No member of the legislature may serve on the commission. All members must be appointed for a fixed term of years, which must not be less than 3 or more than 5, during which a member may only be removed for inability to discharge his function or for misbehavior. The quarantine period imposed by making it a requirement of eligibility that a member shall not have served in any public office within the last 3 years, and also making him ineligible for appointment to any public office for 3 years after ceasing to serve as a member of the Commission, is clearly intended to avoid any risk of his being influenced in favor of the executive by considerations of advancement in his own career. So that is the rationale for the creation of Chapter 9 and these independent service commissions.
Just pausing there, the result is that if you, for example, work as a teacher in the public education sector, you have protection. If you work as a teacher in the private education sector, you don't have that protection.
Well, my lord, at the time, there would not have been really much of a private education sector in Trinidad. Okay. So now it might be said yes, there is some element of that. Yeah. And the short answer is yes, subject to the Equal Opportunities Act.
Yes, you would have the ordinary protection of employment law, but you wouldn't need this constitutional protection because if you worked in the private sector, you wouldn't be vulnerable to the sort of pressure by government ministers, the political pressures that are being guarded against.
Yes, and I think the distinction, my lord, is this: if you're in the private sector, you don't wield and command the authority and power of the state, and you know that's the important link. That
I wonder. I mean, if you're a school teacher, for example,
yes,
well, it's taking the idea of the power of the state quite a long way.
yes.
Postal workers, we know from postal workers, at the time when that was a public service,
Yes.
they were protected. Now, a postman doesn't exercise the power of the state,
No.
but he would be, or she would be, vulnerable to the risk of being dismissed because he wasn't of the right ethnicity, for example,
Sure.
or being victimized.
Sure.
And so he receives the constitutional protection by virtue of working in the governmental service, and by reason of that position being vulnerable to improper political pressures. Is that right?
Yes. Yes. And, I mean, my lord, that principle in Endell Thomas, those passages I've cited, have been repeatedly affirmed by Her Majesty's Board and concretized in our own local jurisprudence in numerous cases. It was the board, in one of the cases I did before the board, was Cooper and Balbosa and the Director of Public Administration in 2006, for example. But can I take you to a more recent one, which is the Perch judgment, which you've mentioned, my lord? And can I take
Before we move to Perch, could I just ask you about the rationale, Mr. Ramlogan? I understand that it's intended to protect civil servants, to protect employees. Is there a wider rationale of it protecting the public from exposure to the misuse of governmental power?
Yes, my lord, I think that's the necessary counterpart to it, because the idea, for example, if I use the Postal Service, for example, if you lived in a certain part of the country or in an opposition-controlled constituency, for example, one may argue that you can allocate less resources, considerably less resources there, thereby, having a disproportionate amount of postmen, for example, servicing a government-controlled constituency, for example, and the public would suffer.
A stronger example might be a function closer to the core of governmental power than the operation of the postal service.
Yes, absolutely, yes. Which is why Perch is so important, because I think in Perch, Lord Bingham had to contend with the fact that, look, we've moved on a bit from the days of the postman being as important, and he had to confront the fact that the Postal Service was now being placed in a statutory corporation, and he did not relinquish in any form or fashion the important constitutional central point made in Endell Thomas, which is that there must be some inherently intrinsic governmental functions which, given by the very nature, must be performed by public officers who are given that protection.
Well, I mean, this is the nub of the case.
It is.
And I think in trying to work out the rationale of working out the rationale of Chapter 9 is really the nub of the case. We've seen, and you've explained very clearly to us that in your submission there are two purposes which are very closely related. One is to protect individual civil servants from improper behaviour, victimisation and so forth, favouritism and the like, which is politically motivated, to which they might otherwise be vulnerable in Trinidad and Tobago, so long as their futures could be determined by politicians.
Yes.
And the related other purpose is also to protect the interests of members of the public,
Yes.
who might be deleteriously affected by, for example, having postal deliveries biased according to whether you lived in an ethnically Asian or ethnically Caribbean African part of the island. Now, on either of those rationales, the vulnerability and the risks to both individual and public interests, the risk to those interests arises from the employees in question being institutionally part of government and therefore subject to the direction of ministers.
Yes.
Now, so in principle, if they are removed from the public service and are no longer vulnerable to the same pressures, then neither the public interest nor their individual interests would call for the same protection. The rationale would have disappeared.
Sorry.
But on the other hand, one might be concerned as to whether what on its face might look like an arrangement that took them outside the civil service and took them outside the scope of political power might not in practice work as in that way.
Yes, but the argument would be that by removing them from the protection of the constitutional shelter given by Chapter 9, they remain, even the vulnerability would remain, but they would now not have the protection because, as you would see from the Act, the minister appoints, ultimately the government would get their appointee as the Director General, for example, and he wields an enormous amount of power. So the short point is it would be a raw and naked exposure to political influence when it comes to a very, very sensitive and important issue such as the enforcement and administration of tax.
If I can sort of illustrate the point I'm trying to explore with you from experience in the UK, where there's been a lot of privatisation of what traditionally would have been regarded as public services. Now, an example is prison officers.
Yes.
There are now privately operated prisons which have contracts with central government. And if you're working as an officer in one of these private prisons, you are answerable to your employer, this private company. And you have no relationship with the government. Your promotion prospects, the risk of discipline, the risk of being sent to a prison in some remote part of the country, all of that has nothing to do with the government. So if the prison service had remained part of the government service, one can understand you would need the protection that Chapter 9 gives. But once you become an employee of a private security company, you no longer require the Chapter 9 protection.
That's true, but the prisoners might require the protection. I can see, for example, a situation, because you've mentioned the duality. It's protection of the public service, but in the public interest.
Yeah.
So, for example, a prison officer who might be highly commended by his contracted employer for running a tight ship and having a great sense of discipline would be promoted. But he might be beating the prisoners to a frazzle and abusing their fundamental human rights in order to run that tight ship. Whereas, so that he might be maximizing profit for the private company.
Yes, I mean, obviously there are risks associated with privatizing prisons.
Yes.
Absolutely no doubt about that. And the sort of problem that you mention is not a purely theoretical issue. But you wouldn't require, but that's not but that aspect of the public interest, that risk to the public interest, that the pursuit of profit might lead to prisons not being operated in an appropriate way. That's not the risk that Chapter 9 is designed to guard against. I mean, Chapter 9 is designed to guard, so far as the public interest is concerned, against politicians putting pressure on, for example, prison officers to behave in an improper way.
Yeah. My Lord, the answer is this, I think. There's more than one way to skin a cat. And the short point is, respectfully, I don't think it's an answer to the insulation principle to say if we take them out of the remit of Chapter 9 and allow them to be in a private entity, that somehow removes the fears and the risks and consequences that would have been associated with the rationale for having them under Chapter 9 in the first place. In fact, if you remove them from the protection of Chapter 9 and you place them in a private entity or something where the government has the direct control over, then what you do is you, in fact, jump from the frying pan into the fire, because you place them now, they are now at the mercy and behest of the government. So that in that quasi-private authority or statutory corporation, as the case may be, the minister becomes the puppet master. And he will have a direct say and sway. I can say, for example, the whisper, the Chinese whisper goes down the line. You can get promoted if, for example, you audit political finances of the opposition.
Well, this is I mean, I don't want to monopolize this, and we need to hear you. But this is the issue I was perhaps hinting at a few minutes ago, that at one extreme there might be what is clearly a purely commercial enterprise, where there is in reality no political influence being exercised. And on the other hand, you might have some sort of agency which is much closer to government, although not formally part of government, where political influence was still a real possibility.
Yes. Yes. Well, yeah, which we say is this case, that the halfway, the interposition of this authority under the control, direct control or indirect control of a politician in the form of the Minister of Finance, we say it is inconsistent with and clearly in conflict with the clear structure of the Constitution insofar as Chapter 9 goes.
And you'll show us the provisions of the Act that sets
Yes.
up the authority that make good that point.
Certainly, my lady, certainly. Can I just turn to the Perch judgment at page 4750. At letter G, you will see Lord Bingham cites Lord Diplock And he says, Chapter 9 of the Constitution governs appointments to and tenure of public offices. Provision is made for a police service commission, teaching service commission, and relevant to these appellants, a public service commission. All three commissions are so composed, structured, and regulated so as to ensure that they are independent and immune from political pressure. The object being to ensure that civil servants, police officers, and teachers are similarly independent and immune. Lord Diplock had explained the purpose of these provisions in Thomas and the AG in a way which, although directed to the 1962 Constitution, remains opposite. And then at page 4753, he says, Mr. Fitzgerald's next and all-important contention, which is that the Postal Service operated directly by the government before 1999 remained a postal service operated by the government despite changes in the Act, in the means by which the service was delivered, since the new corporation was subject to close governmental control. This was not a pure privatization, therefore, but a postal service run by the government in a different way, and those who worked for the new corporation worked in the service of the government in a civil capacity, just as when they had worked for the old postal service. They remain entitled to the protection of Section 121(1), and it followed that the power to appoint to the new corporation or remove them from the post office was exclusively vested in the Commission. Mr. Strachan QC for the Attorney General took issue with that argument and submitted that those employed by the new corporation were not holders of any public office and were not employed in the service of the government in a civil capacity. So the perspective from this, in this particular case, turned on the issue of whether they could have been said, they could be said to be employed in the service of the government in light of their new status in the new Postal Service Corporation. Yes, and at paragraph 13.
I'm sorry, I don't want to keep it in.
No, that's all right.
But is this form of words, persons engaged in the service of the government in a civil capacity, is that a definition of civil servant? I'm not sure.
It's in the Constitution. It says yes. Yes.
Right.
And at letter D.
It'd be helpful if at some point you can give us a reference to the provision in the Constitution.
Certainly, my Lord. Certainly. At letter D, the draftsman intended to draw a contrast between transferring to the new corporation and remaining in the public service. Those transferring were not regarded as remaining in the public service, hence the provision that the terms and conditions on transfer should be no less favorable than those enjoyed in the public service. The draftsman's intention is by no means irrelevant, but it cannot supersede the view properly to be taken on the substance of the matter. So he looked to the substance of the matter, and he says the 1999 Act exemplifies a widespread international trend, towards the divestment by governments of functions previously carried on by them directly or indirectly, but forming no part of the core functions of government, such as defense, maintenance of law and order, and administration of justice. We would add it to that list in parenthesis, taxation, administration, and enforcement of tax, and lending themselves to commercial, non-governmental operation in the interest of efficiency and economy. Now, might I pause there to say that it's interesting that he uses the phrase lending themselves to commercial, non-governmental operation, because the issue of taxation as an incident of statehood and government, a sovereignty, is one that does not readily fit into the category of something that would be for commercial gain, as it would be. Because
the rationale we've already established isn't confined to core functions of government. The rationale of Chapter 9 isn't confined to core functions of government.
No. But this judgment, Lord Bingham, qualified it, as it were, qualified it to say if it was sought to devolve the police service or the prison service to a corporation analogous to the Trinidad and Tobago Post, there would be strong arguments, on which it's not unnecessary to pronounce, for holding that such a change contradicted expressed terms of the Constitution.
Yeah, so he's referring there to the establishment by the Constitution of the commissions for the police service and the prison service.
Yes, and the assumptions on which it is based. No such problem arises here because there's nothing intrinsically governmental in collecting and delivering letters and parcels any more than there is in operating telephones, trains, lotteries, and meteorological offices, or scientific labs, libraries, or hospitals. The list of examples we see is simply not conducive to the addition of tax, the administration and enforcement of tax laws. And protection of the borders. So we say, insofar the axis of our case is located in this paragraph, insofar as Lord Bingham attempted to draw a concentric constitutional circle to ring fence the concept of an intrinsically core governmental function, which is a non-negotiable bare minimum for Chapter 9. We say tax definitely falls within it.
Well, that's part of his reasoning, but he goes on to explain, if one reads on, that although the government reserved a significant measure of control over the new postal corporation, below H, but the minister's power of direction did not extend to operational matters, and significantly, it said, the board was to be composed of persons who, reading short, had relevance, experience relevant to running a business.
Yes.
It says this was intended to be a commercial business.
But that's the point of distinction. This was intended to be a high-grade commercial business. I mean, in other words, it's for profit. It's a high-grade commercial business, and that's where we say the conceptual distinction lies. Taxation could hardly be described as a high-grade commercial business for profit. It's perhaps the consideration in the social pact between the state and the citizen that you pay tax to the government. It's an incident of statehood and democratic governance, but it is not something that can readily lend itself to fit into that category. And that's why we say, on the basis of this judgment, we find ourselves within the concept of inherently core intrinsic governmental functions that can't be removed from the purview of Chapter 9.
Paragraphs 14 and 15 are also perhaps relevant. Lord Bingham's addressing really the argument that was being advanced by Mr. Fitzgerald that although the Postal Service had been put in the hands of a statutory corporation, there remained the danger of political interference. And his answer in paragraph 14 is that the employees would enjoy ordinary employment protection, and the minister would be susceptible to the court's jurisdiction if he purported to direct board members to act in an improper way.
Yeah. My Lord, my answer to that is this. The framers of the Constitution would no doubt have had within their contemplation the fact that public officers in the public service would have available to them the remedies that available at common law and in any other statutory provision outside the Constitution. But that's not to the point, respectfully. The framers of the Constitution wanted to make it abundantly clear and certain that insofar as certain aspects of intrinsic governmental functions go, they did not want to leave it to chance. The Constitution is the supreme law, and because it's the supreme law and Parliament itself is bound to obey the Constitution, in those circumstances, they provided the constitutional shelter and protection in addition to, and quite separate and apart from, the other ordinary legal remedies that would be available to private workers in the private sector. Because, the remedies that are referred to there at common law or statutory provisions would be remedies that would be available to everyone. But they wanted to provide something addition for the public service and as qualified in this judgment, the intrinsic core governmental functions to ensure that it was given a constitutionally reinforced legal protection.
In paragraph 15, we find the source of the phrase employed in the service of a government in a civil capacity.
Yes.
It's section 3.1 of the Constitution, which I see defines public service as meaning the service of the government of Trinidad and Tobago
Yes.
in a civil capacity.
That's correct. And you see, someone in a private corporation, by analogy, will not be in the service of the government of Trinidad and Tobago. And I think what that phrase means, the legal connotation is that you are exercising the power and authority of the government and the state when you're acting in that capacity. And I think that's the important distinction. My Lord, you will find that constitutional provision about acting in a civil capacity in the service of the government at page 4360. But it's exactly as it says in the judgment, but the reference is page 4360. So to the extent that Perch dealt with the relatively mundane issue of postal services, we say that that might be on the lower end of the spectrum, libraries and all the examples that were given. But we say we are at the opposite end of the spectrum. We are closer to home, and we fall squarely within the circle of Chapter 9, inherently intrinsic governmental functions. I mean, this case is, might I say that the case is of extreme importance because in a small society such as ours, this principle of constitutional insulation is important because if you have indirect or direct political influence, you can target the journalists who are not singing from the same hymn book as the government. You can target elections are coming, you can target political finances of the opposition party. You hit them and audit, and that sends the right message to them in a very subtle way, on the eve of an election as to where you should or shouldn't donate, as the case may be. But you can easily have a sense of subtle, quiet manipulation and oppression, utilizing the powers given by the tax and by the laws that you would have that are in the schedule to the submissions, and that's the danger. That's the danger, and that's the fear. And it's not that you have to provide evidence of it happening, but as Lord Diplock says, the risk of it happening is sufficient to to respect the supremacy of the Constitution and the importance and the wisdom that would have led to the peculiar constitutional arrangements for Trinidad and Tobago.
So really, you treat Lord Bingham's statement that there's nothing intrinsically governmental in the Postal Service as a ratio of this decision.
Yes, it is, and that's why I think the examples he gave, are all rather mundane examples that are conducive to the concept of a business for commercial gain. And the examples he gave, would be telephones, lotteries, meteorological offices, scientific lab, libraries, etc. But certainly, we say taxation falls at the extreme opposite end of the spectrum.
Is it part of your submission that anything to do with tax is intrinsically governmental, or are you accepting that some elements, what we might call administration, management, collection, could be, as opposed to certain other aspects connected with taxation?
I mean, my lord, the answer to that I'll give is this. I think it's a process that starts with imposition of tax and ends with the enforcement. And that continuum, that legal continuum, one has to be careful about dissecting it in the absence of a clear statutory provision. And one of our complaints, which my learned friend Mr. Strang will address you on, is the fact that there is no intelligible distribution and allocation of the functions in the Act, such that one can say, well, we are justified and comfortable in adopting a compartmentalized approach to interpreting the legislation. If, for example, the Act were to clearly spell out and demarcate the boundaries of the various steps in the process and hive off one or the other, then that would be a matter then we can address your lordships on. But that's not the case before you. The case before you, the process for taxation from imposition of a tax to enforcement is a continuum that is a composite whole. There is no attempt in the Act to differentiate or distinguish between the various stages of taxation, and insofar as there is an enforcement division, there is no real attempt by the Act to say what are the functions and what are the powers that would reside within the enforcement division.
Well, the Act does identify different functions of the authority by reference to different parts of the tax administration process in Section 6.
Yes.
So assessment and collection is differentiated from administration of the law, which is differentiated from enforcement.
I accept that, my lady. The difficulty is when you go outside, when you step outside of that provision, nowhere in the Act is there an attempt to apply those concepts in a differential manner.
But would you not find that in the Income Tax Act, for example? Because the Income Tax Act surely distinguishes between the different stages. So if you look at the Income Tax Act, you've got charging provisions, you've got a basis of assessment, you've got computation provisions, and then you've got provisions that enable you to get a credit or a repayment.
Yes.
And then presumably you've got enforcement provisions.
Yeah. Well, Milady, the answer I give to that is this. It's not readily apparent as to where the authority, power, and discretion exercisable in the name of the government or state begins and ends in that process. And we don't accept, for example, the Court of Appeal's rationale where they seek to confine the principle to only the exercise of coercive power, which is not defined per se. Because you may have, for example, outside of the raw enforcement, who decides who is to be selected for an audit? If you have limited resources, as all public bodies do, who decides who I'm going to select for an audit in an election year or in any year? Is it the Director General? Is it the Director of Enforcement? Is an audit a step which is the most important trigger to and could close down a man's business, quite frankly? Who exercises that power? Is it in the enforcement division or not? And with the audit comes the powers of search, entry, demands for answers, inspection of books.
Well, if you question the authority of a particular official to undertake an inquiry, you could challenge that. And the courts would have to decide on the interpretation of the legislation whether whether this particular director was the right one to undertake the inquiry or whether it was somebody else.
Well,
I suppose that one has to identify who has the protections of Chapter 9 in order to decide which individual has the protections. You've got to understand whether he is exercising assessment powers or enforcement powers or collection powers. So the protection of Chapter 9 will only kick in if you have a clear idea as to who is protected.
yes, I mean,
And that requires you to have a clear idea as to the division of the responsibilities as between the two.
Absolutely.
But on a slightly different question, ignoring this particular piece of legislation, is there any reason why collection is a core governmental function? Collection of taxes.
I'm not,
Is there any objection to collection of taxes if it had been properly defined, not being a core governmental function?
I can see that collection perhaps might not necessarily fall within the heart of the matter, because you do have, for example, a value-added tax which is collected by merchants on behalf of the government.
PAYE.
PAYE. But again, there is no discretionary authority and power exercisable, as it were, at the behest of the state.
But even if there were, my Lord Reed's point is that the person can appeal to an independent judicial body with an appeal to the Court of Appeal.
Well, yes, that would be possible. But the point I make is simply that they are simply applying, the law. I mean, value-added taxes is a specified percentage. PAYE is normally, there's a formula with a specified percentage, and all you do is you apply it mathematically to the salary, and you know what you deduct. So that doesn't present any real challenges or problems per se. The element of discretionary power and authority that we are speaking about, I don't see it as looming as a larger concern in that aspect of the matter.
But so are you saying collection can be divided up into those decisions that are taken that are a mere procedural calculation and those that have an element of discretion?
Yes, because our submission is that insofar as the concept of what is an intrinsic, inherently governmental function goes, we see that the answer to that lies in how we define it, and it's not possible to give an exhaustive or definitive definition, but we say that an intrinsically governmental function is one involving the exercise of power and discretion on behalf of the executive government or the state, with the authority to make a decision that can affect legal rights, obligations, and liabilities. So, to the extent that in the service of the government, you are clothed with the authority to make a decision that can affect legal rights, obligations, and liabilities. We say that power and discretion is what makes a difference, and that's where we draw the circle.
Can I just see if I've noted that correctly? You say a core governmental function. You say it's not possible to give a definite
Yes, of course not.
definition, but you're proposing one involving the exercise of power or discretion on behalf of the state that can alter legal rights, obligations, and liabilities.
Yes.
Right.
Yes.
Are you going to be coming back to Perch? Because I had one more point to raise.
I'm happy to deal with that.
Well, at the top of page 4755.
4755, yes?
Letter, just above letter B, we're told B.
Yes, thanks.
We're told it is established that a legislature or a government may abolish a public office in the interests of good administration, and some authorities are
Yes.
cited. And then if one goes down the page, paragraph 16, we're told that the judge had held that the provision of the legislation that altered the Postal Service was incompatible with Section 121 of the Constitution insofar as it abolished the offices of postal officers. And we're told Mr. Fitzgerald didn't seek to support this reasoning, since it is not a breach of Section 121 for Parliament to abolish a post in the public service, as the Court of Appeal rightly held. Would that also apply to what you've called core governmental functions?
I think, my Lord, the answer would be yes, with a qualification that you can abolish an office, but the important qualification is that the abolition of the office has to be with lawful justification. In other words, it can't be done with an ulterior motive or purpose, because then it would amount to, it would fall perhaps within the concept of removal of the officer, or, for example, if it's done for an ulterior purpose, for example, it's a disciplinary move under the guise of abolition.
Well, I was really asking the question in relation to abolition by legislation, which is what Lord Bingham was dealing with.
Yes.
If Parliament can abolish public offices,
Yes.
is that an unrestricted power?
I believe, my Lord, can I think about that?
Yes. I mean, it's perhaps an unfair question, because we haven't looked at any of the authorities which which deal with the point, which are listed in paragraph further up the page.
My Lord, can I progress? Can I just make the point, my Lord, by taking you to page, if I can turn to the Court of Appeal's judgment, page 3394.
Which paragraph?
Page 3394.
Which paragraph?
Oh, sorry, beg your pardon. It's at paragraph 86.
Thank you.
87. And at 86, the Court of Appeal says, in the present appeal, the words core governmental functions is not an expression found in the Constitution. Mr. Ramlogan conceded as much. So that the task of the appellant is to show it's implied into the Constitution and that certain functions are core and therefore non-delegable. We accept, however, on the authority of Perch, that implied in the Constitution is the principle that there exist functions that by their nature are non-delegable. This is the clear effect of the words of Lord Bingham and Perch. The question that must be resolved is what are those functions and whether they include any or all of the stages of taxation. Now, I take you to this passage to just to make good the proposition that in both courts below and in Trinidad, we accept as a constitutional principle the fact that there does exist certain core governmental functions that are non-delegable. And that is the finding of the Court of Appeal in this matter. And there is no cross-appeal on that finding. What we are about is not to decide whether that circle exists, but to populate it and to see whether or not the issue of taxation falls within it.
But one difficulty is that a constitution is meant to be a document that endures for centuries.
Yes.
And ideas about what are core governmental functions change over time.
Sure.
In this country, for example, tax hasn't always been collected by government.
My Lord, the answer to that would be, with respect to Trinidad and Tobago and the constitution that we have, and the fact that tax has always been collected, by the government.
Yes, since 1962. So
yes, and even prior to the arrangements we had as a colony. But the point is, the issue of private collection, as it were, has never been on the radar. And if that has to happen, then I suspect you would have to do like they did in 2006. In 2006, they wanted to amend. They wanted to take the jurisdiction of the Police Service Commission and give it to the Commissioner of Police. So they wanted to remove the jurisdiction to appoint, discipline, and transfer workers, police officers, from the Police Service Commission and create a sort of autonomous police service and give it to the Commissioner of Police. How did the government go about doing that? They amended the Constitution itself to reserve to the Police Service Commission the jurisdiction for the Commissioner of Police and Deputy Commissioner of Police, but expressly provide for the transfer of the jurisdiction from the Commission to the Commissioner of Police for the rank below Deputy Commissioner of Police straight down to Constable. But that was done by specific constitutional amendment. So if, for example, that
required a 2/3 majority.
Yes.
So it's done with the supermajority.
That is the point. That is the point. So that it's not that we are not arguing that it's an impossibility, but it has to be done in accordance with the Constitution, and that we say is a clear example as to how it was done in one instance where Chapter 9 was going to be impacted upon.
That's because there's an express provision governing the police.
As there is for the public service.
But not tax.
No, but not tax. But we've got to look at the substance, and the point is the function of tax and the work that is to be done is done by the public service. And insofar as if you want to remove that aspect of the jurisdiction, then we say it should have been done in the appropriate way as contemplated and envisaged by the Constitution itself. Can I? So, I mean, so my Lord, the question here is not whether there is this concept of core non-delegable function, but rather simply whether taxation falls within that concept. And you can see that from even the agreed statement of the agreed SFI at page 3466, which says whether the Court of Appeal, having accepted that there existed governmental functions that are non-delegable, whether it erred in finding that such non-delegable functions are limited to those that exist involved in the exercise of coercive powers, etc. So the simple issue here is whether the administration, collection, and enforcement of taxes and the enforcement of border control measures falls within that concept. And I want to just red flag the border control measures because the Court of Appeal simply ignored that when it's an important part of the case as well. Because unlike taxation, border control is clearly an aspect of national security which finds itself squarely within the dictum of Lord Bingham in the Perch case. But we say taxation is an essential function of government, and the persons who are carrying it out must necessarily be doing so on behalf of the government. And we say they are given weighty, discretionary, and invasive powers to exercise, which they exercise with the authority of the government. We say in the case of border control, that obviously is an exercise of territorial sovereignty, which includes the enforcement of the state's borders and the exercise of control over what crosses the borders, which is an essential function of government, which again is exercised with weighty discretionary powers with the authority of the government. My learned friend Mr. Strang will address you on why we are concerned about the unintelligible distribution and allocation of functions and powers under the Act, which leaves it open to the discretion of the ministerially appointed Director General in terms of how they allocate powers. And the idea floated by the respondent that the court can somehow cure that conspicuous deficiency in the legislation, we say comes perilously close to rewriting it and superimposing, the court's view on what government's policy may or may not be on this thorny issue. Now, my Lord, in this concept of core governmental function, it's not entirely new. We have cited in the US, for example, in the United States of America, for example, we have cited the Federal Activities Inventory Reform Act, and it speaks to the question of an activity or function that is so intimately related to the public interest as to require performance by federal government employees. So the litmus test is intimately related to the public interest. We say taxation clearly falls within that. Closer to home, in the UK, you will find references to it in international law that deals with sovereign immunity. You will find it in the concept of the emanation of the state concept in the Gilbert and Trinity House case, where it speaks about the delegation by the Crown of its own authority to particular individuals. And of course, it's mentioned in cases concerning citizenship, immigration, national security, border control, foreign policy, law enforcement, and we say taxation. They are certain critical key functions that are characteristic and incidental to the concept of democratic statehood and sovereignty. And we say taxation is one of them.
I think my Lady Simler asked earlier on, and I don't want to take you out of your way, one of the issues is whether or not the semi-autonomous body, the authority, is in fact subject to the real possibility of political influence. And I think at some stage you are going to address the mechanics of how that can occur in this particular circumstance, in this particular case.
Yeah, my Lord, can I take you to the Act itself then?
Yes.
To deal with that. It starts at page 4465. And you will see in the definition section, you will see the definition firstly of border control, because I've been at pains to point out that the courts below ignored this aspect of our case. Border control means the regulation of exports and imports from and into Trinidad and Tobago, the regulation of conveyances entering or departing from Trinidad and Tobago, the patrolling, surveillance, and protection of the borders of Trinidad and Tobago.
I'm sorry, you're reading 4465?
No, I'm on 4466.
I'm sorry.
On the definition of border control. I apologize.
Yes, thank you.
So we say when one looks at A, B, and C under the definition of border control, it falls right smack in the heart of the concept of national security. Enforcement on page 4467 is defined as, in relation to customs laws, the Excise Act and other revenue laws. It means the exercise of powers, authorities, and privileges conferred by those revenue laws. And the revenue laws are defined as meaning the laws in the schedule. On page 4468, section 6, the authority is the functions of the authority are, and my lady kindly alluded to this earlier, assessment and collection, administration of the revenue laws, enforcement of revenue laws, enforcement of border control measures, subject to subsection 2, provision of revenue collection services, facilitation of legitimate trade, and to advise the government on matters. Now, my learned friends say that these functions are to be separated from the question of the rights and powers that are given by the Act. And we say that these functions tell us what by law the authority is expected to do. And therefore, on a purposive construction of the Act, whatever powers are given must be serviceable and in fulfillment and pursuit of these objectives and these functions. At Section 7, there is a board of management, and 7.2 says the board shall be appointed by the minister and shall comprise 9 members. And you will see at F, an attorney at law, G, chartered or certified accountant, 2 persons from the private sector. I mean, these can all be supporters, political supporters of the government. That's the point. There is absolutely nothing to insulate this board, to give it any modicum of political insulation and protection as with the Service Commission. It's the minister in his complete judgment and political judgment and discretion, and he can appoint whomsoever he likes. It can be the party treasurer, PRO, and chairman.
It's not subject to positive approval by the Parliament, is it?
I think it...
But if it was, it would be a 50% approval.
Yes, that's...
But is it subject to approval?
My lord, just one second. No, I don't think it is, my lord. No, it isn't.
Yeah.
It's the Director General's appointment that is subject in Section 13.
Was the same true of the board in Perch?
Yes, it would have been, yes. That's correct. And if I take you now to page 4471, this is Section 8, subsection 2. In the exercise of its functions, the board shall not be responsible for the functions of the authority as specified in Section 6, and shall not provide specific directions to the Director General or any employee of the authority with respect to any of the functions of the authority. And then in 3, it says the minister may give to the board such general policy directives with respect to the carrying out of its functions under this Act as he considers necessary or expedient, and the board shall give effect to such directives. And then we come to Section 13, staffing of the authority, on page 4475. And Section 13 says the minister shall, by notification, subject to the affirmative resolution of Parliament. So, my lord, this is the affirmative resolution part. Appoint the Director General and such number of Deputy Directors General of the authority as are required, on terms and conditions to be determined by the board, except that one Deputy Director General shall be a public officer and shall head the Enforcement Division. But as my lord quite rightly noted, this is simply a simple majority in Parliament, and the government of the day will have its sway. Section 14, at page 4476, the Director General shall be responsible for, subject to subsection 2, the daily management and direction of the administration of the authority, the daily management and direction of the functions of the authority as specified in Section 6, including the enforcement of revenue laws by means of civil proceedings. Can I pause there? Because to the extent that the respondent's case is that enforcement is easily compartmentalized in the Enforcement Division, and it's to be done by public officers under the jurisdiction of the Public Service Commission, we say this is a clear example. The Director General is someone who will be ultimately the government's pick, and that person has a specific role and function and power, which is including the enforcement of revenue laws by means of civil proceedings. And he's not a public officer. He's not appointed by the Public Service Commission. And he's in charge of the daily management and direction of the entire authority. And that's where the backdoor for political influence and control easily slips past us. The civil proceedings are obviously a means to an end, and the means to an end is for enforcement. But he gets to decide who he issues civil proceedings against. Whose business do you garnish? Whose business do you distrain and distress? And the full plenitude of powers that you can exercise that are non-criminal but civil in nature. Civil fraud. I mean, all sorts of, a whole wide range of powers. I mean, in taxation, you get to the criminal stage of things after, quite frankly, you've exhausted the civil. The civil comes, it's the prelude. That's how it is in reality.
One could apply Lord Bingham's reasoning in Perch pretty much directly to this. If you look at section 13, all this hinges on the susceptibility of the Director General to being essentially the political puppet of the Minister.
Yes.
Now, section 13.1 you took us to, which is the necessity for an affirmative resolution of Parliament to appoint the Director General.
Yes.
Then subsection 2 requires that the Director General and the Deputy Directors also shall be persons who have a minimum of 5 years demonstrated skill and experience in the area of tax or customs administration, corporate management, accounting, etc.
Yes.
And have the capacity to manage and direct large and complex organizations. And then 3 was a disqualification of people involved in politics.
Well, it's not a disqualification of people involved in politics.
Specifically members
Yes.
of Parliament or members of the Tobago House of Assembly or of municipal corporations.
The difficulty, my lord, is this: what 13.2 does not say, and is in and you'll have to read in parenthesis, sotto voce, is and shall be a loyal, long-standing member of the political party in power. That's the point.
Well, one could have. When we looked at Perch,
Yes.
we saw that Lord Bingham looked at very similar provisions in
Yes.
Perch, and concluded that the scheme was establishing a commercial enterprise.
Yes.
One might just as well have argued in Perch that it was perfectly possible, and I wouldn't be surprised if it was argued in Perch, but it was perfectly possible for those in charge of the Postal Service in its new statutory corporation form to be the puppets of political masters.
Yes, save and except that the extent of invasive and the plenitude of powers given to affect a citizen's rights, liabilities, obligations, and duties would really not arise in the context of postal services as it does.
Well, we went over this, and you explained how, in fact, Lord Bingham refers to the Post as being a notorious example of what Lord Diplock had warned about, the wholesale dismissal of people because their faces didn't fit when there was a change of government.
Yes, but I think it qualifies it by explaining that this is a relatively mundane aspect of government, and he gives Jus Generis, he gives examples, things like libraries and so forth. I mean, that's why I introduced the important qualification to the attempted definition to say, well, it's got to be some discretionary power exercised on behalf of the government in the name of the state, which has the potential, at least, to affect the rights, liabilities, obligations, and duties of the citizenry. And that's the important qualification I make, because that doesn't arise in the context of postal services, but it definitely arises in the context of civil proceedings at the behest of the Director General and in the context of taxation, which amounts to, coughing it up for your property. I mean, you can lose your house. Your business can be closed down. It has implications for your livelihood and all sorts of things. Taxation is a very draconian matter because the remedies that are given, to the taxing authorities are pretty extensive and invasive.
we also know that it's a function which has been delegated to external bodies in many countries.
Yes, but with the remarkable difference that they don't have the constitution that we do.
Yeah.
And Chapter 9 doesn't exist. And that's why...
I mean, we'll come to it, but aren't there similar constitutional protections in constitutions of other Caribbean countries which have taken this sort of step? I'm thinking of Barbados and Guyana.
Well, no, I have to say that we've looked at the Guyanese cases cited by the respondents. I haven't seen anything else cited by them. So I'll have to, I'm learning from Mr. Strang will deal with the Guyanese cases. But can I just complete my read of the Act? Yep. But, my Lord, what I will say, my Lord, is simply we've got to bear in mind we're dealing with a specific constitution, which is the Trinidad Constitution. And if I then move on quickly to page 4477, and you will see at subsection 3, this is 14.3, the Enforcement Division of the Authority shall comprise the Deputy Director General of Enforcement and such other public officers who may, for the purposes of the enforcement of the Customs Laws, Excise Act, and other revenue laws, exercise the powers, authorities, privileges conferred by those revenue laws, and such other employees of the authority as the board thinks fit. Now, there are two ways to read this, because it could mean that those concerned with enforcement in 3A are people to be appointed by the Service Commission and their public officers, and that's their sole preserve. But the other way to read it is that they, in conjunction and or together with such other employees of the authority as the board thinks fit, will also have a role in the enforcement, in the work of the enforcement division. At subsection 4, the Public Service Commission, we are told, shall appoint, remove, and transfer the Deputy Director General. And we are told in the performance of his functions in subsection 5, he is subject to the Director General is subject to general directions of the board, who is he's also subject to the general directions of the Minister. And the Deputy Director General of Enforcement on page 4478, top of it, carrying on C, the Deputy Director is subject to the general directions of the board, which shall be communicated through the Director General, and he is also subject to the general policy directions of the Minister, and that is the Deputy Director General in charge of enforcement.
Well, does 3 not mean that under A, the enforcement of the customs laws is entrusted to public officers, but other employees of the authority can be employed in the enforcement division, for example, I suppose, as secretaries.
The short answer is yes, that is obviously one way to read it, but it's also, it's also possible to read it the other way, and it begs the question, why would you have that provision given that there's an existing public service? And if you look at the public service, there are clerical officers, every administrative support and conceivable thing that you can need already exists in the Board of Inland Revenue and the Customs and Excise Department. Why would you want to put that clause to give now the authority to insert non-public officers, whom you say you're just simply transferring wine from one bottle into a new bottle? Why have that provision?
Well, because the people who, in this country, might be called inspectors of taxes, for example, are going to be exercising the kind of discretionary powers that you've been talking about, which affect people's lives. And you might want those people to remain public officers who have the protection of Chapter 9, whereas the people who work in the department as messengers, clerical staff, and so forth, aren't in the same category.
Well, I accept that, my Lord. I accept that. Of course, query on an intelligible distribution of functions and powers, whether they will have access, for example, to files and records for taxpayers, etc. I mean, there's a lot that one can unpack into that. But now, look, having regard to time, my learned friend, Mr. Strang, needs to address the board on a couple issues, and I think, unless there are any further questions, out of deference to his diligence, I must give way to him.
Yes, thank you very much indeed.
I'm deeply
Mr.
obliged to the
Ramlogan.
board. I thank you very much.
Yes, Mrs. Dhoray. Just take your time to get organised.
Just while Your Lordship was asking those questions at the end about why these provisions at Section 13 are insufficient to protect the political immunity of the Director General. I mean, one answer that occurs to me is the point is it's still significantly different from the provisions under Chapter 9, which is the constitutional requirement, and because the Minister has the power of appointment, the power of removal and disciplinary control are not made express in the Act. By implication, under the Interpretation Act, the powers of removal and disciplinary control of the Director General also reside with the Minister. So those are two important points in answer to that question. But what I propose to do is, given that we've set out the definition of government function, one involving the exercise of discretionary authority on behalf of the executive arm of the state, I propose to look at some of the powers given to officers under two of the relevant acts to carry out those functions under the Income Tax Act and the Customs Act, to look at examples of the exercise of discretionary authority. But before I do that, just to finish off looking at the Act, we were at Section 14. So the Lordships and your Ladyship have seen the division of responsibilities between, at least the proposed division of responsibilities between the Director General and the Deputy for Enforcement. This is at page 1476. And then the purported allocation of functions to public officers in the Enforcement Division Act 14.3 at 4477. The other provisions that allocate functions come at 4487. Where we have Section 39. Section 39.2. It's called a savings provision, but it's effectively a sweep-up provision to make sure that all functions under the Acts are now transferred to the authority. We're going to look at some of those functions now. And then over the page at Section 40, references in the laws to and at 41A, the chairman of the board or the controller, with again the purported distinction between enforcement and any other matter, including civil enforcement. And then at B, any reference to the board should be construed as a reference to the authority. So having done...
Do you see this exclusion from enforcement of civil proceedings presumably leaves us with enforcement only by criminal?
Well, I would say that is the natural way to read the intention. I'll come to that, but if enforcement... we'll come to why the enforcement definition is circular in some parts in the allocation of functions, and the respondent's response, I think, impliedly accepted by the Court of Appeal, is that we use the ordinary meaning of enforcement, but it must mean enforcement except by way of civil proceedings, because that's reserved to the Director General. So I'd say the most natural way of reading the intent of the drafters is that they must have meant enforcement by criminal proceedings. So criminal enforcement, the prosecution and punishment of offenders, and the enforcing the payment of penalties and fines. Now, I'll come on to the respondents' much more expansive definition of enforcement than they've put to the board in their case. But before I do that, I'd like to go to the functions under the...
Just to put a point to you. Clearly, like any legislation, there are a number of questions about the interpretation of this that might well arise. If and when they do arise, they would have to be decided by the courts in Trinidad in the light of the Constitution, so as to arrive at a result which was constitutional rather than unconstitutional.
Sure. Oh, because I'm leaning down. Right, gotcha.
Your lovely voice singing.
Thank you, Derek. All right. Gotcha. Thank you. That's all right. That's better. All right.
What I was bringing to you is, clearly there are possible issues of interpretation. If those arise, the legislation would have to be interpreted in the light of the Constitution, and if possible, it would be interpreted in a way which was in conformity with the Constitution.
Yes.
If that couldn't be done, then the provision being construed would have to be held to be invalid.
Yes. Yes. To which I would add, my Lord, that when we're talking about allocation of powers and functions to various departments within the authority, it's much better that the allocation be predictable now rather than be tested in 5 years' time after the wrongful use of a certain power by the wrong person.
This is the reason I'm raising the issue, because what we're being faced with is a challenge to the whole enterprise of this legislation, on the basis that the transfer of revenue functions to a statutory corporation is incompatible with Chapter 9 of the Constitution. Now, there might be more targeted issues as to whether a particular provision is compatible with the Constitution or not. But those may be fences, as it were, that are further down the track. We're dealing with a blanket challenge to, that's a rather pejorative way of putting it, perhaps, but it's a root and branch challenge that we're dealing with here.
Well, the claim form identified certain provisions that would be void according to our claim. But I suppose the point is, if certain governmental functions are to be transferred to the authority, they need to be intelligibly and reliably transferred to public officers. And if the Act doesn't do that, it may be possible to interpret it to make sure that it does, but in this case, because we're talking about an enforcement division, and in our case we say that governmental functions extend way beyond enforcement, even in the ordinary meaning of the term, it's hard to interpret. It's hard to interpret the Act in compliance, save by making sure that all exercises of powers under the Act end up in the enforcement division. So you only have one division of the authority. In my submission, that's where we end up. I say. So, what I propose to do is turn to the Income Tax Act, just to look at some instances of the exercise of discretionary authority on behalf of the executive arm of the state. Because, and the income tax is at 4162, Income Tax Act 4162. We've set out a fuller account in the schedules to our case, but I just wanted to pick out some examples of decision-making powers and discretions, of the exercise of adjudicatory powers, and the exercise of powers of inquiry, examination, and investigation. So,
This is Schedule 2 to your...
yes, Schedule 2. But at the first stage of assessment, when chargeable income is being calculated, there are many decision-making powers and discretions given to the board to decide what counts as chargeable income, what deductions may be made. These might be considered more minor discretions, but there are many of them. So, for example, when we start looking at chargeable income at 4193, the kinds of decisions that the board makes are, for example, here at C, this is 10.1c, satisfied that expenses are reasonable in amount, or at 10.2, satisfied that outgoings are extraordinary and non-recurrent, or 4198, I'm going to, perhaps I better not go to all the examples because I think we're short on time. 4198.
I'm sorry, the page was?
4198, then we have a decision whether bad debts have been proved. These are the kind of decisions that are made when considering chargeable income and what deductions may be made. And to determine all those questions, the board has the power to require evidence, and that's at page 4214. So at section 17, to determine all questions as to deductions from chargeable income, the board has the power to require evidence. And then there are other decisions which can be quite momentous.
But all of those decisions would be capable of challenge before
Yes.
an independent judicial
Yes.
tribunal of some kind.
Yes.
And there will be established case law that guides
Yes.
taxpayers and revenue officers as to how to make those decisions.
That's right. But they're still being made by somebody who's no longer under the protections of Chapter 9.
No, I understand
And that
that.
would still apply under Chapter 9, but Chapter 9 is still considered to be an important part of the Constitution of Trinidad and Tobago. So,
Are you accepting that there are sufficient safeguards for the taxpayer?
well, Chapter 9, I say, is the sufficient, is the constitutional safeguard for the exercise of governmental powers.
For the taxpayer as well?
For the citizen, yes, it's part of the constitutional safeguards for the citizen who's subject to this exercise of discretionary authority.
Well, that guards against the officer who's making the decisions being subject to improper political
Yes.
pressure.
And it
But
protects
it doesn't
the public too.
provide a safeguard for the taxpayer for a wholly capricious decision.
No, but it is a protection to the public, Chapter 9, because it says that important functions should be exercised by people who have the protections of the public service. It's not just to protect the officer, it's to protect the person who is subject to the officer's decision-making.
In any event, the advertisement of a bankruptcy petition might have an adverse impact on somebody that they have difficulty in recovering from.
All kinds of decisions. And because there are so many discretionary decisions, it's not that easy to challenge them in judicial review. We'll come to some...
Well, presumably the power of appeal in relation to these
Yes.
discretions is the,
Yes.
the tribunal exercising their own.
Yes,
Yeah.
Indeed. Perhaps I should move on to some of the more weighty... I'll leave aside, but we have... Let's go to estimates and demands for payment. Let's go to assessment and the general powers of the board. And that begins 4278. So here we are at payment of tax. This is a section about payment of tax. And
So you're still on assessment at the moment?
Yes. We're moving to we're coming to the actual act of assessment here. So under payment of tax, the board, of course, has a power. This is 79.4 over the page, 4279. In the absence of a return, the board can estimate the amount of tax, and of course that.
So is it self-assessment?
Yes. So returns are filed.
Yeah.
In the absence, and once you file a return, you're liable to pay an amount on account under 79.1, and if you don't, the board can estimate 79.4. That's 4279, and that gives rise to an immediate liability to pay on account. And then we come to assessment, which is the next phase after the estimate. And assessments begin at 4282. So we have here at section 83 the power to accept or reject a return. 83.2. Accept the return and make an assessment, or refuse to accept and make an assessment. And then at subsection 3, to assess in the absence of a return. And then at subsections 4 and 5, discretion to charge additional tax, unless satisfied that, this is in the event of failure to disclose, unless satisfied that wasn't fraudulent or willful, or in the event of failure to provide a return at subsection 5, unless satisfied that there was a good reason for that. And then section 86 is the board's power to hear and determine objections to assessments. So these I would characterize as adjudicatory powers. Power to permit an objection, a late objection at 2 and 3, and then at subsection 5 to reconsider the assessment.
So that would be analogous with the internal review mechanism that's available in this country.
Yes. So, and I characterise that as an adjudicatory power, because you're adjudicating on an objection, and you're making a decision as to somebody's liabilities to the state. And you'll see here under subsection 5A a reference to the board's powers under section 97 to require evidence. And section 97 is at 4294.
Are you coming back to the appeals in section?
Yes, there's a power of appeal to the appeal board.
And that would be to an independent?
Well, yes, the appeal board is...
section 87.
Yes, the appeal board remains the same.
Yeah.
Yes. And then, yes, I was going to show you section 97, 4294. So this is the board's power to require evidence and information. Failure to comply with those requests is an offence. My learned senior mentioned distress and garnishment. They are sections 104, which is page 4302, and section 112, which is page 4307. But I'm going to move on to the general, under the section and those come under the section that's called collection and recovery. And under the general section at the end of the Act, I'm going to come on to some important powers of the board at page 4311. So the board can require of any person information about the income and assets of another person. At subsection 1. A failure to comply with the board's request under that section is an offence at subsection 5. The board can also, at subsection 2, require the same information of a bank, but in that case, it has to give notice and under subsection 3, and the person concerned can apply to a judge for a declaration of his rights in the matter. And then, over the page at section 118, is the board's power of entry. For any purpose related to the administration or enforcement of this Act. I draw attention to that because of administration or enforcement. And entry is for the purpose of auditing or examining books, examining property, and requiring anybody concerned with the business to answer questions and give all assistance. At C, and at D to search, and at E if it appears there's been a violation, to seize and take away. And the point I make about this is to summarize the powers under the Act, that they include discretions and decision-making powers, they include adjudicatory powers, they include powers of inquiry and examination, and they include intrusive investigatory powers. And I compare that to what the Court of Appeal said about the process of assessment, 3399, which we say is wrong, in paragraph 102. page 102, the Court of Appeal said that the assessment which the authority is empowered to conduct is in reality an arithmetical stage of the process and does not confer on the assessor any coercive power. Well, leaving aside whether coercive power is the right dividing line, the assessment stage goes way beyond an arithmetical process because it involves adjudication, inquiry, and intrusive investigatory powers. I would do the same exercise for the Customs Act, but we don't have time, so but I will come back to one or two parts of the Customs Act.
You rely on your Schedule 3?
Yes, the schedule at Schedule 3 sets out a list of what we call the exercise of discretionary authority.
I'm having difficulty in understanding what a customs officer does if he's not enforcing, if he's not actually enforcing the border controls. Can you help me there?
Well, he's enforcing border controls. Is he enforcing the law within the meaning of enforcement under the Act, and with the meaning at Section 14.3 is a more difficult question. We can take a quick look at the Customs Act. May I come back to that when we talk about enforcement? Because that's what I'm going to do now.
Yeah. Do bear in mind you don't have a great deal more time.
Yes. So, what I want to consider, having looked at some of the functions of the authority, is to consider what functions are reserved by the Act to public officers. Because, as your lordships know, our submission is that not all of the governmental functions of the authority are successfully reserved to public officers. And so we go to back to section 14.3 at 4477. Which is the reservation of powers to public officers. 3A. And the problem with this reservation on the face of it is that enforcement is defined in the Act at 4467 at the top of the page. The exercise of the powers, authorities, and privileges conferred by the revenue laws. If we apply that at 4477, we have an impossible circular definition, which I think is accepted by both parties now. 3A at 4477 would read, such are the public officers who may, for the purposes of the enforcement of the revenue laws, may for the purposes of the exercise of the powers, authorities, and privileges conferred by the laws, exercise the powers, authorities, and privileges conferred by those revenue laws. So we have an impossible circular definition. And the respondent says this problem is resolved by using the ordinary meaning of enforcement, where enforce the law means compel observance of the law. The Court of Appeal didn't expressly address the problem or the respondent's answer, but it appears to have impliedly accepted it. At least it took it that enforcement here is meant to mean measures to collect unpaid taxes. And we'll see that at 3398. So this is where the Court of Appeal, at paragraph 100, defines enforcement as a stage of taxation. At 100, subsection 4. Measures to collect unpaid taxes, and then agrees with the judge at paragraph 101 it should be treated separately from the other stages of assessment and collection, and then having considered assessment and collection at 102 and 103, at 104 says enforcement continues to be performed by public officers under section 14.3 of the Act. So the Court of Appeal says section 14.3 means the collection of unpaid taxes is, measures to enforce the collection of unpaid taxes is reserved to public officers by section 14.3. Now that's somewhat different from the meaning of enforcement proposed by the respondents. I make 2 points about the ordinary meaning. First, as it is proposed by the respondents and as it was understood below, it's not a reliable or stable solution because different definitions have been advanced under the supposed ordinary meaning, and the respondent now proposes an expansive meaning for enforcement which isn't based on a clear or reliable or principled definition. And the second point I make is that in any event, if one is to resort to an ordinary meaning of enforcement, properly applying that, a significant number of governmental functions, as we would define them, fall outside the function of enforcement of the authority, of the enforcement division. So section 14.3 doesn't successfully reserve all governmental functions, as we define them, to public officers. So what I say about a number of different meanings being advanced under the supposed ordinary meaning of enforcement, first of all, as we've just seen, the Court of Appeal took it to mean compelling the payment of unpaid taxes. In the courts below, the respondent didn't sketch out the boundaries of what the ordinary meaning would be, but some of his submissions suggested that he identified, as I just did, enforcement as entailing the exercise of police and prosecution powers. For example, at 3183.
Is it possible to give the paragraph number?
Yes, paragraph 65.
Thank you.
To the extent that the enforcement powers under the laws include police powers of arrest or the laying of criminal charges, the Act's being careful to ensure that the personnel who will be charged with those functions will continue to be public officers. And as my Lord Burrows just adverted to, I would suggest that the exercise of criminal prosecution powers may be most likely what was originally intended by enforcement under Section 14.3, because of the dichotomy in the Act between enforcement by way of civil proceedings, which is allocated to the Director General, and the rest of enforcement, which is allocated to the Enforcement Division. So if Enforcement Division carries out enforcement other than by way of civil proceedings, a natural way of understanding that would be criminal enforcement, as I described it earlier. And of course, and the revenue laws provide for a very large number of offences. So one can understand why the authority would have a criminal prosecution department. But in the respondent's case now before the board, we get a much expanded meaning of compelling compliance with the law. And this is at 3528, paragraph 28. And it seems in order to try and capture much more of the intrusive powers of revenue officers, for example. So 3528, paragraph 28. And 29.
29, they seem to accept that.
So
they seem to accept that both assessment and payment involve elements of enforcement.
I read the respondent as trying to expand the definition of enforcement to try and capture more of the intrusive, or what we call governmental powers that are exercised by assessment officers. So in 28, we have the exercise of coercive investigative powers to obtain information to be used in accurately assessing the tax that is legally required to be paid. Is just as much for the purpose of securing or compelling the payment of outstanding taxes as is the exercise of coercive powers to secure payment of taxes that have been assessed but not paid. Well, that's a much broader use of the ordinary meaning of enforcement than simply compelling observance of the law, as I'll show. And it effectively collapses the difference between enforcement and assessment.
You could say the same about paragraph 29.
Yes.
I'm not certain what it means by such as opposed to the exercise of coercive investigative powers, such as inspection, search and seizure. I'm not quite sure what that means.
And for the purpose of facilitating the accurate assessment, well, that's simply administering the law, not enforcing some compliance against somebody who hasn't observed the law. Because if we're going to use the ordinary meaning of enforcement to understand Section 14.3, then accepting that it is compelling compliance with or observance of the laws, that includes two ideas. One is enforcement entails coercive action. Two is enforcement arises when somebody has failed to observe the law. There's no need for enforcement if somebody's obeying the law. Whereas these examples here are applying to instances where there's been no failure to observe the law. And I'll show that when I go on to my second point now, which is that if we use the proper ordinary definition of enforcement, it doesn't cover all occasions on which officers under revenue laws, exercise discretionary authority on behalf of the executive. So, one example which is separate from enforcement is, of course, the exercise of adjudicatory powers that I pointed to earlier. That is an exercise of discretionary authority with significant impacts on the rights of individuals. But let's turn to the powers of inquiry and investigation that we looked at Section 117 and Section 118, 4311. And bearing in mind what I said, that enforcement arises when somebody's not observing the law under the ordinary meaning proposed. So under Section 117, when a revenue officer requires a person to provide information about somebody else's assets, and that person in response gives up all the information sought, that person's requiring with the request and complying with the law. So no need for enforcement arises. But an intrusive power has been exercised. It's an intrusive power short of enforcement. Enforcement arises under Section 117 if the person refuses to comply with the request, and that's subsection 5. Same again for the powers of investigation over the page. Now, an officer decides to audit a business. That means he or she can require entry, require sight of all books, examine anybody involved in the business. Now, if given notice of that decision, that's under subsection 2, the business can choose to comply immediately, or if aggrieved, they can refer to the judge under Section 1174, ask the judge to declare, the business can ask the judge to declare its rights under Section 1174. Now, if the judge declares the board is entitled to decide to audit this business, the business will be expected to comply with any requests to permit entry and show all the books, and that's all in accordance with the law. If the business then provides all the information to the revenue officer, there's been no failure to observe the law. So no question of enforcement arises. But an intrusive and extremely far-reaching discretion has been exercised by the officer. Enforcement arises at subsection 7. It's an offence to hinder or molest any person exercising powers under this section. May also arise at subsection 3, where the officer can go to a magistrate where he apprehends that admission to premises might be refused or has been refused. But the decision to audit and the compliance with that decision, it isn't enforcement. And the same point can be made about, and I hope this partly answers my Lord Stevens question. The same point can be made about similar powers of search under the Customs Act.
Am I right in thinking that the new authority has no power of prosecution?
Well, all the functions under the Acts are transferred to the authority. I'll try and identify where the powers of prosecution come, to the extent they do. That's something I didn't.
The Director General is responsible for the functions of the authority are specified in Section 6, aren't they?
Yes.
And we know they include civil enforcement.
Well, they include enforcement of the laws.
Yeah. But it has, as far as I can see, it has no power to prosecute, in which case references to enforcement must mean civil enforcement.
Well, what I'll do, my Lord, is is try and identify within the revenue laws where powers of prosecution are, because those will have been transferred to the authority by Section 39(2).
I mean, under the previous law, or under the existing law, I should say, does the Trinidad revenue have a power to prosecute?
But that's what I'll try and establish from the revenue laws. Yes, I was just going to finish with the Customs Act. Let's take a look at Section 59, for example. It's 4063.
Yep. I should say you're eating into your reply
Yes.
time, provided you're aware of that.
Section
59, 4063. I suppose this is an illustration of the difference between enforcing border control measures and enforcing the law, as in compelling observance of the law. So in order to enforce border control measures and to regulate goods, regulate the passage of goods, for example, officer under Section 59 is given power to enter any ship, search any part of it, open any cargo. And that's a discretionary power with an intrusive and far-reaching effect. An officer can decide to be satisfied with a quick search, or can decide to search a boat from top to bottom for days. But its exercise doesn't arise from enforcement of the law, as in the sense of compelling observance of the law, where somebody is refusing to observe the law or has failed to observe the law. If an officer enters a ship and asks to search every part and inspect all the goods, and the master of the ship complies, there's been no failure to observe the law, and no need for enforcement, as defined, arises. Enforcement arises if the master resisted the officer or tried to hinder the officer, and that would be liable, that would be an offence under Section 5(1) of the Act, of the Customs Act, which is at didn't have the reference in my papers, sorry. I'll get there very quickly.
How does it work? Are there random entries by officers onto ships, or is there some reasonable basis for suspecting that there's been a failure to comply with the law in relation to declaration of goods or cargo being imported?
Well, I'm not sure I can give a full account of the policies of the.
But you keep asserting that there's been there's been compliance with the law, and none of this is to do with enforcement. But at one level, it is all to do with enforcement, because my understanding of the position, certainly in this country, is no customs officer can, without a reasonable basis for thinking or suspecting that there has been a failure to comply with customs laws, can exercise these intrusive powers.
Well, it doesn't say so in Section 59.
No, but certainly in this country, again, I'm sorry I keep mentioning it, the Taxes Management Act governs how officers of the Revenue and Customs go about exercising discretions and search and seize powers that arise under other acts. Are there other acts that govern the approach to the exercise of discretions and the exercise of these sorts of intrusive powers?
I can't answer that, my lady. There are many acts, but this is the main act. So yeah. If this power was governed by statute, it would be in this act. Right. On my reading of the understanding of the structure of what is a very complex structure of excise and customs laws. The point is that I would say, for example, in search or in, for example, in auditing, there's a justifiable discretion to carry out examinations and investigations, not only where there's a suspicion of wrongdoing, but also in order to be, also for purposes of a check, to satisfy oneself that generally things are being conducted in the right way, mistakes aren't being made, to understand how the laws are being complied with. These powers are not simply, they don't simply arise where there's a suspicion of wrongdoing, in my submission.
I see there's a requirement of reasonable grounds for searches of persons under Section 64.
Yes. And that's where there is that 64 is much more like an enforcement power, because there's reasonable grounds. Yes, and just beyond that, and I know I'm going to have to finish, but 67 at 4066 is power of arrest. So there are instances where the grounds for suspicion or the grounds for exercise of the power are made express. But I'm aware of the time, and I'm going to... Okay. Prosecutorial powers. My learned senior has just identified some prosecutorial powers in the Income Tax Act at 4316. This is an, well, let me just check. This identifies the offence. Yep. 121A, sorry, yes, sorry, I got the wrong one. Section 121A, subsection 2. So there's the prosecutorial power of the authority.
Well, that's the prosecutorial power of the board.
Yes, but which now becomes
that's
the authority. Yes, that's transferred by Section 39(2). Or, and by Section 40, subsection 1A.
Sorry, it's transferred by Section 39(2).
39(2) and Section 41A. A reference to the board in respect of enforcement would be to the Director General Enforcement. So that's probably Section 121A(2). The board there would read Director General Enforcement, assuming that we're talking about that we all have a stable definition of enforcement. And Section 246 was at 4128. This is a different act now.
Sorry, could you give the references again, please?
So I'm now going to the Customs Act. So that was the Income Tax Act. It's 4316, Section 121A.
I've got the Customs Act. You're moving. I've got the IT Act. You're now moving to the Customs.
I'm moving to the Customs Act.
And the reference is?
The first one is 4128, Section 246.
Thank you.
I think it's, the reference you gave just now, I think it should be 41B, shouldn't it? Because that's you read the board as a reference to the authority.
Let me just go to the Act.
With the chairman, powers of the chairman of the board or the controller.
Yes. Well, it's interesting because that's probably a lacuna in the Act, in that the prosecutorial powers, enforcement, the references to enforcement are references to the board, not to the chairman of the board. So there's a lacuna there in Section 40.
What's a lacuna?
Well,
we were looking at Section 121A2 of the Income Tax Act, and it says that the board can authorise somebody to prosecute.
Yes.
And the new Act tells us in 41, a reference to any written law to be the board shall be construed as a reference to the authority.
Yes. Well, yes, that's true. There isn't a lacuna, but I suppose I'm looking at what was intended by 41A, which was to make sure that where the prosecutorial powers are referred to, they are directly transferred to the Deputy General,
Well,
Deputy Director with
41A
reference to enforcement.
doesn't say anything about prosecutorial powers.
No, for subsection 41A, little Roman 1. I mean, it's not that, I don't think it's that important. It's just occurred to me that B should probably have had the same division as well as A, because the Act means to transfer prosecutorial powers to the enforcement Deputy Director.
Well, the way his powers, when you go back to section 13, I think it is, the entirety of the powers, including enforcement powers, are transferred to the Director General, but it's subject to subsection 2, which then gives the Deputy Director General enforcement.
Yes, so I suppose you're right to say it tidies up there.
Yeah.
Yes. But reverting to the Customs Act, let's see, 4130. There's the prosecutorial power of a customs officer under the Customs Act. Is it section 252?
Now, you have now used up your reply.
I'm going to
also. So.
I'm going to stop there. I think we've taken about 15 minutes of our reply time. We started late.
No, we'll see what progress we make.
Thank you.
Thank you. Mr. Mendes.
May I inquire up until what time we'll be going?
Well,
now, I think,
would it make sense? I don't know. Do you want to speak for 5 minutes, or would you rather we adjourn now and resumed 5 minutes early?
I think it's better 5 minutes early.
Fine. Well, in that case, we'll adjourn and resume at 1:55.